This is Michael Popok with the Legal AF Hot Take. Let's get ready to rumble down in Florida with the Judge Cannon and the Department of Justice, who are doing battle once again over whether Judge Cannon understands or misapprehends the law, the defenses related to the Mar-a-Lago espionage and obstruction case against Donald Trump. In this quarter, we have the Department of Justice, who claims that this judge, Judge Cannon, as it relates to the defenses Donald Trump has and the application of them to the Espionage Act that he's been charged with and the obstruction count, that she has exhibited fundamentally flawed legal premises, in this quarter. In the other quarter, we have Judge Cannon, who's taken umbrage to being attacked for having fundamentally flawed legal premises, and she says that that commentary, that critique by the Department of Justice is unprecedented and unjust criticism. Who's right? Who's wrong? When does Jack Smith take his appeal already to the 11th Circuit Court of Appeals and perhaps seek Judge Cannon's reassignment? I think we're almost there. Let me break it all down for you. We got a new ruling from Judge Cannon in which, on the surface of it, I'm sure the headline that was reported was, Judge, in setback to Trump, denies motion to dismiss indictment under the Presidential Records Act. Yeah, that's sort of true. But when you read the 3 pages, and that's all there was, when you read the 3-page order, and I'll do it for you here, at least parts of it, we're not quite out of the woods yet, kids, as it relates to the fundamentally flawed legal premises of the judge. What's the battle? The battle that's going on right now is that the judge seems to be struggling unreasonably with 3 different concepts and how they intersect with each other, or if they intersect with each other, and it goes to the heart of the case. Remember, the indictment against Donald Trump in Mar-a-Lago is effectively 3 counts. You've got the Espionage Act, which is the retention, holding on to a national defense information documents that you are not entitled to hold on to. And that violates the Espionage Act. Obstruction of justice is all of the, once caught with those documents, Donald Trump refused to return them, then used in a conspiracy, a number of people around him to hide them from the Department of Justice, federal judges, the National Archive, magistrate judges, the Department of Justice, FBI agents, and the like, through subterfuge, through surreptitious means, lying to his lawyer and the like. That's the obstruction count. Then there's conspiracies around all of those things. That's where we're at. Donald Trump has always said, well, through a feat of alchemy, I converted all of the documents that were top secret classified national defense information documents, that whole pile, when I took it with me, I converted it into personal records, even though that's impossible. I did it not through a presidential declaration or executive order on the way out. I just did it mentally. Like, I thought about it, poof, and they became personal records. That's his defense. And he brought a motion to dismiss the indictment, now, like a month before the trial was supposed to be, a little bit late, claiming that the Presidential Records Act, which allows a president to declare that certain documents are personal, is his primary defense to the case and should lead to the dismissal of the indictment. And the judge, as I said, good news, bad news, the judge says, yeah, I didn't really see how you describe properly the application of the Presidential Records Act as a defense to the Espionage Act. And the Espionage Act has been properly indicted or properly laid out in the indictment, so I'm not going to dismiss it. But she left open the door that he'll be able to use the Presidential Records Act at trial as a defense in front of the jury when it can't possibly be a defense. The fundamental misapprehension that's driving the Department of Justice and Jack Smith absolutely batty, like mad as a hatter, is that there's no Venn diagram where those two things intersect, right? The Presidential Records Act does not allow a person like Donald Trump to convert into his personal property national defense information documents, top secret documents, classified documents, documents about the nuclear capabilities of our friends and foes, other highly, bombing strategies, war strategies. He doesn't get to keep that as mementos on the way out. All right. So it's never a defense. Certainly it can't dismiss the indictment. It can't be used as a defense. But you have to read this new motion, this new order, this 3-page order, which I'll do in a minute. You have to read it in the context of what she did last week, in which she instructed the both sides, Trump and the Department of Justice, to assume 2 scenarios and write proposed jury instructions to teach the judge the law. Which is sort of odd anyway. We're not close to trial yet. No trial date's been set, and she's struggling with what jury instructions should look like, which is weird in terms of timing. She might be doing it, as I said earlier, as a teaching exercise where they get to teach her the law through how they draft their jury instructions. But the 2 premises that she gave on the jury instructions are both fundamentally flawed. I mean, the Department of Justice said they can sort of live with one of them, but the other one is just dead on arrival. She said, in her scenario 1, she told both sides, assume that Donald Trump, assume that that Donald Trump had the right to just declare the documents under the Presidential Records Act to be personal. Then what happens to the crime? Well, that can't be what the jury instruction is, because that all tips the scale substantially in favor of Trump and puts the prosecutors back on their heels. And they probably can't win a trial that's framed that way in front of a jury. The other one is that the other scenario they should assume is that the prosecutors have to prove that the documents were not personal in nature and therefore that the Espionage Act could apply. And that one, the prosecutor said, if we have to live with one of the 2, we'll take on that burden. We can prove that documents are not personal in nature, right? They're not, this case we talk about a lot on Legal AF and on our Patreon. The Sox case, where Bill Clinton took personal audio recordings, dictated things into a handheld that he was going to use for his future memoirs. He kept those tapes in a sock drawer in the White House. And Tom Fitton and others tried to get a hold of those and say they were presidential records. And so the fight was presidential versus personal. And of course, the courts declared that the socks drawer tapes were personal to Clinton, even though they were about his presidency. So the prosecutors are willing to take on that fight. Judge, you want us to teach the jury that it wasn't the personal to him, the nuclear codes, the Iranian war plans weren't personal to him? We'll take on that responsibility. But we think you're wrong and fundamentally flawed there too. What their worry is this concept of double jeopardy, which again, on one of our Patreons, we'll do a deep dive, is that we go to trial, right? She allows a fundamentally flawed jury instruction to be given, and the jury acquits Donald Trump. And then the prosecutors, because of what's the concept of double jeopardy, can't retry the case, perhaps even after appeal. And that troubles the Department of Justice. Do you know Fast Growing Trees is the biggest online nursery in the U.S. with more than 10,000 different kinds of plants and over 2 million happy customers in the U.S.? They have everything you could possibly want, like fruit trees, palm trees, evergreens, houseplants, and so much more. Whatever you're interested in, they have it for you. Find the perfect fit for your climate and space. Fast Growing Trees makes it easy to order online, and your plants are shipped directly to your door in 1 to 2 days. And along with their 30-day Alive and Thrive guarantee, they offer free plant consultation forever. I love Fast Growing Trees. I recently got their most popular small avocado tree at a great price. They have an amazing selection to choose from, and their customer service is incredible. And the cherry on top? I save so much money by not using an overpriced landscaper. You don't need to have a yard or a lot of space. You can grow lemon, avocado, olive, or fig trees inside your home, on top of the wide variety of houseplants available. The experts at Fast Growing Trees curate thousands of plants, so you can find the perfect fit for your specific climate, location, and needs. You don't have to drive around to nurseries and big gardening centers. Fast Growing Trees makes it easy to order online, and your plants are shipped to your door in 1 to 2 days. Whether you're looking to add some privacy, shade, or natural beauty to your yard, Fast Growing Trees has in-house experts ready to help you make the right selection, with growing and care advice available 24/7. You can talk to a plant expert about your soil type, landscape design, how to care for your plants, and everything else you need. No green thumb required. This spring, they have the best deals online, up to half off on select plants and other deals. And listeners to our show, well, they get an additional 15% off their first purchase when using the code LEGALAF at checkout. That's an additional 15% off at fastgrowingtrees.com using the code LEGALAF at checkout. Fastgrowingtrees.com, code LEGALAF. Offer is valid for a limited time. Terms and conditions may apply. Now, the judge in this, let's get ready to rumble that I started the hot take with, the judge is daring the special counsel right now to take her up on appeal. Let's go to the order. And again, you got to keep it in the context. It sounds good in the headline. Something got denied for Donald Trump, but when you dig deeper, it still represents that this judge is vibrating on a frequency that's improper and incorrect and legally flawed. So here's the order denying document number 431. That's how many things have been docketed in the case: orders, motions, pieces of paper, that type of thing. Order denying defendant Trump's motion to dismiss the superseding indictment based on Presidential Records Act, which is a primary defense of Donald Trump. Fully advised in the premises, this is on page 2, the motion is denied. If it stopped right there, we'd be like, all right, that's interesting. But the judge goes on. It says that bound by the four corners of the superseding indictment. In other words, she's got to stay within the four corners of the indictment and assume that it's all true for the purposes of a motion to dismiss. She said those same counts make no reference to the Presidential Records Act, right? Almost chastising the prosecutors. Why didn't you mention the Presidential Records Act in your indictment when it doesn't apply to the Espionage Act counts? Nor, she goes on to say, do they rely on the statute Presidential Records Act for purposes of stating an offense? In other words, Presidential Records Act, PRA, is not part of the charge. And she's right about that. Then she goes on to say separately, this is where she chastises and takes great, she's high dudgeon with great umbrage, if you will, about the special counsel. She says at the bottom, separately, to the extent the special counsel demands an anticipatory finalization of jury instructions prior to trial, prior to a charge conference, and prior to the presentation of trial defenses and evidence, the court declines that demand as unprecedented and unjust. All right, first of all, that's not what the special counsel's office is doing. It wasn't their idea. It was the judge's idea to have competing jury instructions, which, based on her homework assignment, shows that she doesn't understand the law. And that's what they're worried about. They're worried that if we get to trial with the judge still not understanding the law, she's the lawgiver in the case. She has to give the law wearing the black robe to the jury. It doesn't work the other way around, Judge Cannon. The jury is not the fact as the jury, the lawgiver, the law finder. They're the fact finder. And if you get all the way that far and an improper jury instruction is given, which leads the jury to make an improper decision, burdening the prosecution with even more of a burden than they need in order to prove the case, and Donald Trump's acquitted, double jeopardy attaches, and there's no other trial of Donald Trump. I mean, that's what Trump's people are trying to pressure the judge to do, to make an error in legal judgment that infects the jury instructions. It benefits Trump and leads to his acquittal. Follow? Okay. So here, she's turned it on its head and said it's the prosecutor that wants her to finalize the jury instructions. No, the prosecutor is criticizing her because the homework assignment about the jury instructions shows she doesn't understand the law in the area. The judge goes on. You can tell she got singed by the prosecutor's paper filings earlier this week. The court's order soliciting preliminary draft instructions on certain counts should not be misconstrued as declaring a final definition on any essential element or asserted defense in the case. Right? In other words, I'm just doing a learning exercise, a teaching exercise for me. Nor, she continues on the bottom of page 2, should it be interpreted as anything other than what it was, a genuine attempt in the context of the upcoming trial to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression. It's almost like she's begging the appellate court to put her out of her misery. Like, I can't figure this out, this law out this late in the game, and I'm leaving it open because it's a case of first impression. Give me guidance, 11th Circuit. She may get guidance. She may also get replaced from the case. She continues, and this is the dare she makes to the prosecutor, and I'll talk about the dare. You don't like me? You don't like my analysis? You don't like what I'm doing as a judge? Take me up on appeal. She ends her order with, As always, any party remains free to avail itself of whatever appellate options it sees fit to invoke as permitted by law. Signed, Aileen Cannon. All right. That is her telling them in polite words to shut the you-know-what up. If you don't like what I'm doing, take me up on appeal. Now, here's the question, timing-wise, and I've done another hot take on this one. You can find it, about whether now is the time under a case and a set of factors in the 11th Circuit we call the Torkington factors. Is it time to get this judge replaced and ask for her replacement by the 11th Circuit? First, you got to get up on an appeal. The question is this order enough? Yes, on paper, it looks like a win for the Department of Justice, but they could just as easily take this up right now. I'm not sure they're going to, but it's 50-50 for me. They could take this order up on appeal and say, look, we got a judge who's painted herself into the corner and created a stalemate because she's doubling down on an improper assessment of the law, and she's having us do thought experiments that are based on her thinking that the Presidential Records Act provides a defense and should be part of a jury instruction, burdening the prosecution with too much responsibility and wrong law to instruct the jury with, which could ultimately lead to double jeopardy and an improper acquittal of a criminal defendant. This is what their argument's going to be. We don't have to wait. I would continue to the 11th Circuit right now. We don't have to wait, justices, until Judge Cannon actually drives the car, off, through the abyss because the bridge is out. We see the bridge is out. We see the judge hurtling down the road at 100 miles an hour, and she's about to go over the cliff. We can do something about it now and get her either a proper instruction from the 11th Circuit about the application of the Presidential Records Act to the Espionage Act, or we do it now. And by the way, here's the laundry list of things she's done wrong in the case, where she has painted herself into the corner. Now she's just fighting with us, not because there's bias per se, but there's an appearance that no justice is being done because now she's defending her wrong-headed earlier decisions and doubling down on them. And that is a factor to be considered by the 11th Circuit under this case called Torkington. Now might be the time. I've implored the special counsel, to the extent that anybody in his office watches, take her up on appeal. I believe the 11th Circuit, and I know a couple of judges up there, I believe the 11th Circuit is waiting patiently to step into this and put Judge Cannon back in her chair, give her proper instructions and a mandate, and or replace her with a more sophisticated and seasoned judge in the Southern District of Florida. We'll continue to follow everything related to Judge Cannon and Mar-a-Lago. We do it one place, and I think it's one place on all of YouTube and the entire YouTube verse. MeidasTouch Network and Legal AF. Join us on Wednesdays and Saturdays at 8 p.m. Eastern Time on YouTube. You'll find out why we call it Legal AF. I think you're starting to get a sense of it by the way we're presenting this particular analysis. And then you can follow me, Michael Popok, on hot takes like this one. You can go over on the MeidasTouch YouTube, slide over to playlists or contributors, and you'll find Michael Popok and all of my body of work. There, all the hot takes that I do, just like this one, about every day, if not every hour. And then, of course, you can pick up our podcast, Legal AF, on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.